Solving Citizen Legal Encounters. Glad to see people coming in to the chat. And tonight we want to have a good little night, little night of fun tonight. We have a few cases. One of them in the beginning is going to be from Judge Satterfield with a sovereign citizen. And thanks to my man Colin, he shared this one with me. I had a busy week, so he looked out for me. So anybody that doesn't know about his channel, check him out. I got to put the link in the description. I think I didn't put it in there yet, but it'll be in there by the end of this video. So I also have a follow-up, again, out of Judge Perkins' court that I went back and looked because a lot of people in his court just seem to not come back. And then I got a couple other videos in there just for fun. I did them sometime last year, and they funny to watch. So we're going to check those out, and we're going to get into it, okay? So you see at the bottom, anybody want to sign up for text alerts? There it is, and let's go.
All right, we'll see what we've got here with Mr. Sehi. Looks like it's a new domestic case involving Shannon Sehi. I'm not really sure why he would have been allowed to have any contact with her whatsoever, given all of his case history with her. Mr. Sehi, it looks like you're back in jail on new charges. There's some of the similar.
Judge.
Yep.
Born on the record, I reserve all my rights under the Uniform Commercial Code, specifically UCC 1-308.
Okay, I'll note that. I'm going to quickly go over the charges with you. You should receive a copy of them and you can just read them yourself. But count one, you're charged with threatening Shannon Sehi on or about the 23rd day of April, 2025 in Butler County, Kansas.
That never happened.
They've not communicated what the exact threat is, but they've alleged that you threatened to commit violence or communicated with her with the intent to place her in imminent or immediate fear.
That's not true.
Okay, so I'm going to enter not guilty. If convicted, 5 months up to 17 months with the Department of Corrections, up to $100,000 fine. Has to run.
Judge, since this is the first court date, I would like the evidence to be presented for it on the record.
Okay, so what happens is, and I don't want to read it out loud, but the judge assigned will get an affidavit. Well, yep, I'm assigned. I will get a probable cause affidavit for this arrest. And if there is probable cause, which is something more than a mere possibility that a crime was committed and you may have committed said crime, then I approve the arrest. But then I go ahead and get your case set for preliminary hearings so that you can have actual evidence with representation, if you want it, for a probable cause finding with
Judge. But I'm not playing anything because, first of all, I was on my own property at my own house, and I had to explain to somebody that she has no jurisdiction in what I do over my house, or even in my house or on the property or whatever. And she called the police on me, and then the police came on my property and said, I don't know what you're here for, but with all due respect, I don't want you on my property. And then they said that, well, we got a call that said that you were being violent and that you were threatening. And I said, well, that never happened, and you don't have to talk to me. You can talk to her. And so anyway, they ended up coming up on the porch, and I opened the door again. I said, I don't want you on my porch. And they said, well, we need to talk to you. We need to find out, And I said, well, I don't know what you're talking about. I'm not violent. Wasn't violent at all. And so he said, well, she wants her keys. And so I said, oh, well, okay. Well, so I gave him the keys. So I gave that dude the keys so she could have them, but she could have came in and got the keys anytime she wanted to because there are no threats. So anyway, the police officers after I gave him the keys, he opened the door and said, well, now I'm going to have to arrest you. He said, you're under arrest for threatening. And I said, I don't know what you're talking about. So I closed the door and I went the opposite direction. This dude kicked in the door and shot me in my back with a taser that burnt my back. Do that again, Judge. Do that one more time. Put the pen to the camera like you did. Did you
Okay, he has a problem.
switch something?
Nah, Mr. Sehi, I did not. Mr. Sehi.
Okay, well, anyway, that's what it is. And they ended up taking me to this place that I'm not supposed to be at because of how you and some other judges and other people abuse me in here. And I really appreciate being in jail. And I want to let you know that you know for a fact that I'm the one that gave those videos out, and I reported how those babies were getting killed and blood was being spread all over the wall. I mean, you've seen the video. You admitted you did on the other court dates. So what is this, Judge? Are you against me having my own property? Are you against me exposing everybody for killing kids?
See how he's trying to flip the script. Now, that part about what he's talking about now, I'm not sure about it. All I know is he's in here for a domestic charge. And Ed, thank you for the super thanks, Ed. The Orioles got you. All right. Yeah, I appreciate that. Yeah, this guy, I'm just going to let him ramble on. You'll see.
For and on the record.
Mr. Sehi, all I'm doing today is
Please stop moving your hand to the camera. You're doing that intentionally.
No,
stop doing that.
No,
you were told that I'm not
Mr.
supposed to be in this
Sehi,
jail. You know for a fact I'm not supposed to be here. Where's the evidence at? For and on the record.
Turn off the audio. Now. Mr. Sehi, in count 2, you're charged with battery against a law enforcement officer, a Class A person misdemeanor. If convicted, it's a maximum of 6 months, $1,000 fine. In count 3, you're charged with interference with the law enforcement officer, resisting arrest. If convicted, it's a level 9 non-person felony. In count 4, you're charged with threatening a police officer, Cody Marvin. It is charged by the prosecutor's office as criminal threat, a level 9 person felony. If convicted, you could receive 5 months up to 17 months with the Department of Corrections, up to $100,000 fine. I imagine count 2 through 4 are incidents that are caught on camera, as most of the officers wear body cams. Probably not count 1. That will have to be the statements of Shannon Sehi as to any reporting of any threatening statements by you or actions by you. I'm going to enter not guilty pleas on all of the charges. I'm going to schedule this case for an immediate preliminary hearing at the first available date I have, as well as I'm going to review the probable cause affidavit that should be submitted by today by the prosecutor's office for e-filing, so that I can determine whether or not they had probable cause for an arrest, and then give you a full hearing on May the 28th at 10 a.m.
So as you see, he's still trying to run his mouth, but he's muted, but he's going off back there. And yeah, Mike, I'm going to look into that because that's a good question about why it's not a felony. I have to see. I was trying to get some background information on this guy, but I can't seem to get the spelling of his name correctly. So I wanted to bring more to it, but I can't figure out how to spell this guy's last name. That's the problem. But I'm going to keep working on it. And actually, his next hearing might not even be aired. So this might be like a one-time deal, but it's just still something to show that we can hang out with tonight.
Now I'm going to set bond for you. And I'm going to ask for a recommendation from the state.
Yes, Your Honor, and the state is recommending a high bond in this case, as may be determined by the court. As part of special conditions, the state would be recommending no contact with any endorsed witnesses or alleged victims, that the defendant can take prescription medication and no drugs or alcohol. I believe the court has already indicated some familiarity with the defendant on the record here today. Additionally, this appears to be a defendant with a history of adjudications and convictions the court may consider relevant. Disorderly conduct and at least 2 battery against the school employee adjudications, as well as convictions for disorderly conduct, misdemeanor assault, domestic battery, criminal restraint, and felony interference with law enforcement. Pursuant to the affidavit, this appears to be a defendant who attempted to barricade himself within a residence, as well as threatened to kill multiple individuals, including at least 1 law enforcement officer. And it would also appear that
I don't like stopping it in the middle, but I guess the truth hurts because he got up and left. And still, even when he was doing all of that stuff, I guess too, a lot of times with the sovereign citizens, some judges don't just hit that contempt charge on them right away because they probably don't want to keep dealing with them over and over again because they're going to keep presenting the same argument. So maybe that's why she didn't do it early and just muted him and just left it at that. But he just said, you know what? I'm done. I'm out of here.
there is another Butler County case, Butler County 21 CR 457, which does appear to involve a journal entry of judgment of direct contempt of court signed by Chief Judge Rickey. And in that case, it would appear that the defendant was convicted of battery in which the victim was a detention deputy.
I know what I should have done, but I didn't. I should have stuck myself in there after he left.
Okay. I'm sorry, what was the amount that you're recommending?
Your Honor, the state is prepared to defer to the court as to an appropriate amount. Certainly, the state would not be opposed to a $7,500 cash or surety bond. However, given the particular facts and the history of this defendant, the state does respectfully suggest a much higher bond is appropriate.
Okay, well, I'm gonna set his bond at 10,000 cash or surety with GPS. Absolutely no contact whatsoever with Ms. Sehi. And I assume she still has his child, but I don't know. I'm actually surprised if they were in contact or living together. If he had remained attentive and didn't leave the room here this afternoon, I would have asked him for any statements he wanted to make about bond. And I probably would have asked him about his living situation and any potential no contact orders with Shannon Sehi. I'm going to assume, since he's not charged with violating a no contact order of any kind, that they were allowed to resume cohabitating, either as he flattened his time or his probation expired or someone lifted no contacts. It's been a while since I've had any cases with Mr. Sehi. My cases with him were disposed of rather quickly. But at any rate, that's the bond. I gave him an expedited, this is actually a preliminary hearing, not a control setting. I don't know if Mr. Watts will have a conflict with representing him. It seems like maybe Mr. Favre has been his attorney previously. So if Mr. Watts does, he can forward the case to Mr. Favre.
David, welcome. You just became a member. Congratulations. I'll be glad to see you when you join us in the chat that we have. And you'll see the instructions in the community post. So thank you for deciding to come hang out with us. I really appreciate it. You'll have fun.
And Your Honor, what I would tell the court is that journal entry of sentencing in Butler County 21 CR 457, it would appear that that journal entry does make reference to Mr. Favre, and in response to the court's earlier inquiry, it would appear that the court did order 6 months in jail, but that the defendant was awarded credit for time served.
Okay, so essentially flattened his sentence. Yeah. Okay. Now, these preliminary hearings are in person. So he's to appear in person, and at least he won't be aggravated with my pen because he won't be able to see anything in my hand in the courtroom when I'm on the bench. But historically, he's failed to come out of his cell. And I don't know if he has a history of failing to appear if he makes bond, but we will deal with that if and when it happens. But this is, as I indicated, evidentiary hearing with witnesses in my courtroom. We are adjourned.
All right. So I don't know if I'm gonna be able to get anything else off of this guy. I think Colin told me he might not be aired because when they in the courtroom, a lot of times, you're not gonna get it. So we'll just see if he shows up once I figure out his last name. But anyway, this one I brought up, I don't know, it hasn't been too long ago, but it was definitely probably towards the end of last year, I think. But it is so funny because you know how Magistrate Burton is if you've seen him, because I just had a live with him, I think. And he shuts him down. He loves arguing with the sovereign citizens. So this was like a one-time deal. I wasn't able to follow up on him because he was supposed to have a hearing here the next day. That wasn't aired. And then he went somewhere else and that wasn't aired. So I lost him. But this is a really good video. It's not that long. But let's check this one out before we go into the next one.
For Strickland.
How you doing, sir?
I'm fine. Has Mr. Strickland spoken? Has he spoken to his attorney yet?
No, he hasn't.
Okay. She's in a breakout room with another person, and as soon as she's done with that person, I'll put you in the breakout room with Mr. Strickland. So it'll be a few minutes, okay?
Okay, sir. I just want to let you know he's not consenting to do a video arraignment.
So what is he consenting to do?
I'm getting him his paper. Is there any paper clips or anything?
Oh my God.
Yeah.
Hold up, everybody. This is somebody I know personally that's been trying to get into their lives. I know them. Like, this is not somebody from here. So Juanita King, Ross, thank you for joining. And I hope you have a good time. Appreciate it. Oh, and also, I think it was Harry. I forgot to answer what you mentioned. I'm glad the text messages are working flawlessly for everybody. From what I'm hearing, I'm getting good feedback on that. So that shouldn't be a problem. I appreciate you telling me that. And also, Sherry just became a member. Congratulations. Welcome. Welcome to the trust. So you get to hang out with us. You'll get all the instructions. Just the community post or Aqua Queen will take care of you. Okay? Let's roll.
Okay. This is the court, sir.
I don't consent to the thing. I'm asking why they can't bring you. Okay, hold on. Does he want to speak to an attorney first?
Yeah, well, let's have him speak to an attorney first. You have to speak to an attorney. You have to.
Hold on. Mr. Strickland?
Hold on. I got to stop it. Mel, you gifted a membership. How nice of you. I appreciate that. And it went to Harry. Congratulations, Harry. Glad you were able to get gifted that membership. So, yeah, you know what to do. Just the same. Check out the community post. But yeah, congratulations. And thank you once again, Mel, for doing that. I really appreciate it. Oh, shit. Y'all see this? Okay, Trish, it's going to be at least an hour because I said this is short doesn't mean this is the last one. All right. I'm not going to do you like that. I'm not going to come on for 5 minutes and leave.
Mr. Strickland, can you hear me?
This is the judge.
Okay. Mr. Strickland,
Open the door.
can you hear me?
This guy.
Can you hear
Oh, you
him?
don't want to hear me?
Sir, can you hear?
What?
Mr. Strickland, this is
Hi.
Magistrate William Burden. Good morning. I'm going to ask you a few questions. Do you want to speak with an attorney?
Who are you speaking with? The flesh and blood man with a name? Because that's what I'm trying to find out right now, Judge. Who are you speaking with? The name entity or the flesh and blood?
I'm speaking to the person that's talking to me right now.
I am executive of the name entity. That's who you're talking to right now. Do you understand?
Mm.
I am the executor of the name entity. I demand to be released on my own recognizance. I have right here, Judge. You see this, Judge? And then I also have a UCC1 in the name entity.
I'm gonna stop right there for a second because the first time I did this video, I didn't really think about it. Now he just got arrested. Normally when they come through there, they just got arrested. So you telling me you get arrested but grab all of your sovereign citizen paperwork to bring to jail with you? That's incredible.
So y'all trying to run a lien on the name, that's illegal. Who are you trying to conversate with? The name entity or the flesh and blood man?
You
I
tell
demand
me.
to be released on my own recognizance. I have a UCC1 here. I've laid claim to the name entity through the Secretary of State and the federal government. Here it is right here, the Secretary of State. Just
Okay. Sir,
it's right here, Lincoln. To the flesh and
Sir.
blood man or the name entity.
sir,
I'm trying to ask.
sir, whether I'm talking to the flesh and blood or name entity, I'm talking to both of y'all at the same time. Do either of you want to speak to an attorney?
No, sir.
Now, see, when you catch them off guard, like what he just did, he had to think about it, which I think is hilarious. Once he said it at the same time, that shut him down for a minute. He was like, wait a minute. I wasn't expecting that.
Okay.
And I don't consent to an attorney. I don't consent to be in no hearing.
Sir, I just asked you one question. I just need one answer.
And I don't consent.
Okay, I know that.
So who are you
Okay.
speaking with? The flesh and blood man or the name entity?
I'm speaking to both of y'all. I'm speaking to both of y'all at the same time. How about that?
You can't. I
Now,
don't.
sir, I know you want me to release you.
Here it
Are
is.
you gonna let me talk?
Here. You
Are
see
you
it?
gonna let me talk?
Wow.
Sir,
Sir?
are you gonna let me talk? I got some questions for you.
I'm here without consent.
Put the paperwork down,
Don't
sir.
consent to this.
I know you don't consent to this. You want the court to release you, is that correct?
Yeah.
Want to release you, the entity, or the person in the flesh? Which one?
I love that. I love that.
Flesh and blood man. I own the entity, so it's going to be released anyway.
All right, now.
For UCC1. Everything.
If you don't, when I talk, you listen. If you don't want to talk to an attorney and you don't want to be arraigned today, we're going to put you over to tomorrow. You understand that?
So we already been through this. I am the executive of the account.
Okay. Have a good day, sir.
Hey, let me ask y'all a question real quick. You can answer in the chat. Do you think he needs a little bit of help? Where's my regulars at? Do you think he needs a little bit of help? Could y'all tell me? Because I'm about to unpause it. I think he needs a little bit of help. I really do. Because obviously he just messing things up. Which one do you want to answer from? Does he need help? I'm about to let it roll. You'll find out what's going on. 1 second. Are you having trouble running your script in court? Welcome to the Sovereign Tactics Institute, the only place where you can turn courtroom chaos into a fiery tuned art form. At the Sovereign Tactics Institute, we'll teach you how to appear fired up while turning the entire courtroom into a chaotic circus, leaving judges flustered and prosecutors so frustrated that they lose track of the case. Master ultimate sovereign scripts that keep everyone on their toes and put you in control of the chaos. Here's a testimonial from one of our clients. Yeah, I went to the Sovereign Tactics Institute. I was struggling with my script, but after the course, I managed to drag my case out for 3 years. The judges were flustered, and prosecutors didn't know where to hit them. Because when it comes to defending your case, mayhem makes all the difference. Don't miss out on this great opportunity today. Call Sovereign 1 or 708-374-4461. Live sovereign, live free. I asked the question. Y'all didn't get it in there fast enough. So yes, that's a new one to go along with what's going on here because y'all asked for another one. So I'm doing another one and there'll be more coming to you. So, I'm sure, I hope you enjoyed that. So this one is, I like that. Do not try this. Do not try this at home. Yeah, I'm going to keep it coming. So this one is Judge Perkins with this guy named Anton Latney, right? And the same old script stuff with this guy. And I covered this already, but this guy brought his birth certificate to court. And you'll see just how wild this guy is going to act. All right, so let's go on in here. It's just a fun night. That's all. Here we go.
Antonio Pierre for the Latney family.
Yes. Can you hear me?
I can. Good morning to you. How is whose case is it?
Sorry.
Latney, Antonio Pierre Latney?
Yes. I'm Antoine.
Antoine, I'm sorry.
Yes.
All right. Good morning to you.
Good day.
Good day. This is the city of Detroit versus Antoine Pierre Latney. His number is SP 1445437. SP 16220-361, SP 1627402, counts 1 and counts 2. Appearance for the record, please.
Sherika Harris, on behalf of Mr. Latney, please state your name for the record.
Here's a special appearance. Here's the bond in question, the birth certificate. I'm the natural person, natural man, and I'm not surety for this bond here, but I got it right here in my hand.
You have to turn your first of all, Mr. Latney, you have to turn your camera on. I can't talk to you without seeing who I'm talking to.
And I withdraw my appearance, Your Honor.
Why do you withdraw your appearance so quick, Mr. Harris?
Because it appears he does not need the assistance of counsel.
Well, we don't know that yet.
I should start my video, but it's doing something like.
Mr. Ostrowski, you might want, I don't know if that's a cigarette. I would take that out if I were you. Good job.
It says start your video, so you got to start your video, all right?
I'm going to use my phone, I guess.
Are you all right? Well, however you do it, I'll pass the matter until you get it together, all right?
All right.
I just let you in on the Samsung. What's your name, sir? Samsung in the blue t-shirt. In the blue t-shirt, walking around the house.
Okay, did I get it fixed now? Did I get it fixed now?
What's your name, sir? Good morning to you.
Antoine. I'm Antoine. I'm representing this.
Oh, you're Antoine Pierre.
Yes, yes. Try to get it fixed.
From the Latney family, right?
Yes, yes. Can you hear me and see me?
I can hear you and see you. Let me get you identified on here. I can hear you. All right. Let's go back on the record with Latney. So Mr. Latney, state your name for the record, please.
I'm making a special appearance. I'm Antoine, the natural man. And here goes his topography, all capital name, Antoine Pierre Latney Bond that you guys are questioning. I'll make a special appearance on this.
Mr. Latney, I have no clue what you're holding up or what you're talking about.
Yeah, that's the birth certificate. I'm holding up the birth certificate of Antoine Pierre Latney.
Okay, and who is Antoine Pierre Latney?
That's I'm the natural person, but the all capitals name, which is topography that you are dealing with the all caps, that's this birth certificate. I'm not that all capital name. The all capital name is this birth certificate right here. I'm the natural person.
I don't know what you talk about. You're confusing me.
I'm confused too. I'm confused too.
Okay.
Oh, he confused too. Yeah, bringing that birth certificate. Yes, Aqua Queen, that's his birth certificate that he brought to court, trying to prove because the birth certificate is in all caps, and he figures that court paper is in all caps, so they don't want him. They want the birth certificate. I don't even know who come up with this script and think it's going to work.
Okay, well, we're both confused. I need to see Antoine. I need to see Antoine Pierre Latney. That's who I need to see.
I'm Antoine in the natural form, flesh and blood, right here. How you doing?
So you're Antoine Latney, right?
No. Are you referring to the all capital name?
Bro, we trying to go. You making this shit longer than it got to be.
I know it.
I'm gonna pass the matter until I get Antoine Latney.
Okay.
All right, Mr. Latney, let's get this over with. Yeah, let's do this because it's gonna linger on. And Mr. Latney, let's go back on the record with Antonio and.
Oh, hold on. I didn't even know you snuck in here, Lone Wolf. When did Hutch start doing eBay? I just like to make sure I acknowledge other creators that pop in here. Y'all know Lone Wolf. I saw somebody, I don't even know how I missed it. It was like, hey, how's you doing, Lone Wolf? I was like, where's Lone Wolf? I had to scroll up. Nice for you to join this, Lone Wolf. I really appreciate you coming through and making comments like you always do. Now let's go.
Antoine, Tony,
for the record,
Antoine Pierre Latney.
For the record, I'm making a special appearance. I'm Antoine Pierre Latney, and I'm making a special appearance for this bond. I do not assume any responsibility for the all capitals name that you guys have in front of you or anywhere else.
Your Honor.
Yes.
All right, I'm gonna put my appearance back on the record. Cherika Harris on behalf of the natural person, Antoine Latney, and I will ask for a breakout room, but I am ready on Johnny Gatewood if we could do that matter first.
We'll get Johnny Gatewood out here. But you know something, Ms. Harris, I don't know if Mr. Latney knows that we get a lot of attention from these bloggers and these
it's just that it's like I drive for a living, but
what did he just say? What did he just say? He drives for a living. So you know he's playing games with the script. He's not real. Somebody probably gave him that script, so he's trying to get out of this ticket. That's crazy.
When I get into my regular car,
Mr. Latney, if I were you, I wouldn't talk. I mean, well, I'm sorry, you might not be Mr. Latney, but the person representing, I wouldn't talk if I were you. Give me a moment to speak with you in the breakout room before you make a whole lot of statements on the record, please and thank you.
Oh.
Okay. All right. So let's I'm gonna put you in a breakout room, Mr. Latney. Have a conversation with you don't object to that, do you? Having a conversation with Ms. Harris?
No.
So have a conversation with Ms. Harris and just wait on her. I'm gonna get Mr. Gatewood out of here and then we'll hear what you have to say, all right?
Yes, sir.
See how easy that was? He wants a deal. No matter if he gets the case, moved to another date or whatever he wanted to do or play the motions game, but the real sovereign citizens don't want to talk to anybody for a couple of minutes. That so you know that's yeah, you know how it is.
That's great.
Let's go back on the record with Latney. Mr. Latney, what is this? How is this dismissed, Ms. Harris?
Your Honor, I've had an opportunity to speak with Mr. Latney. I was able to ascertain that he does have insurance that expires December 2nd, 2024. He did show me his receipt. Mr. Bowman was kind enough to take the receipt for the registration. And he also showed me his Georgia license that was issued in January of 21 and expires March of 29.
Really? Y'all can throw in the comments why he's even doing all of this. It's just a waste of time like they always do. And a lot of times it's for these small cases, especially a lot of traffic stuff from what I see. Now, some of the bigger cases, they do it. Now, I would kind of understand why they would want to go that route on a big case. But expired registration or it just, the court wastes so much time into dealing with this. It's crazy.
My understanding is that would take care of the matters that were before the court. We would ask the court to adopt the recommendation to dismiss.
All right. If that's the recommendation, we will adopt it and to get Mr. Latney on his way. Because I don't know how you check a Georgia license, but we'll adopt the recommendation. Mr. Latney, you still owe $174 for an expired plate, a old expired plate, and $108 for an old no valid registration. All right.
Your Honor, if I can inquire as to how old those are?
They're too old for me to set aside. I can give you the date, but I'm not going to set it aside.
Thank you, Your Honor. I thought I would try.
Yeah, you can't help but try. That's the last year, April the 8th. Dismiss for providing.
Thank you, Your Honor. Mr. Latney, those matters were dismissed, but you do have some that still have to be paid.
All right, Mr. Latney, you understand that?
What was what's the criteria?
No, you just owe 2 old civil infractions that you never paid. An expired plate and a no registration, $174 and $108. The other matters that the court calls into the record are dismissed. All right.
Okay.
All right. Have a great day, sir. Best of luck to you.
Thank you. You too.
A shame. He wasn't a real sovereign citizen, in my opinion. He just ran the script and gave us a good show. But if he was a real sovereign citizen, he wouldn't have took the deal so fast. So see, now his case is over with. So simple. So now we're going back in his court. So yeah, it's funny because Judge Perkins do seem, somebody said in the comments, he do get a lot of sovereign citizens in there. And I don't know, sometimes I feel sorry for him for all the drama. He have a lot of drama in that court. It's just probably the area and the people he has to deal with over there. So this guy I'm actually doing a follow-up on. So I had put his case up. I can't remember when, but it's not too far back. But I've been waiting for him to go to court, and he missed the court date. And I'll get to that when it gets towards that part. But he has a new court date coming up. This case is not finished. So for those of you who have never seen it, is why I just like to show the whole thing as a refresher, especially if it's been like 4 or 5 months, because not everybody sees it. I mean, people come through and they watch the videos, but not every person that's on here going to see every single video that I put up, especially if I have videos like this intermingled with other videos. You might just, do whatever you want to do, but we're going to go into this one now.
Christopher Gray is gonna be up, and then still waiting on street court, Mr. Greer. What is your date of birth, Mr. Gray?
Good afternoon, Your Honor. 7/11/72 is my date of birth. I have a.
Can you say that again? Go ahead, say what you were about to say.
I have a motion before the court, Your Honor.
Let me first start. Do you need a lawyer, sir?
No, Your Honor.
City of Detroit versus Christopher Gray. Case numbers SB 1357945 counts 1, 2, and 3. SB 1191985 counts 1 and counts 2. SB 1629749 counts 1 and counts 2. SB 1267865 counts 1 and counts 2 and counts 3. Appearance for the record, please. State your name for the record, please.
Christopher Lamar Gray.
All right, today is the date and time set for a pretrial, and then there's warrants on the other matters. I'm gonna enter a not guilty plea on your behalf. I'm gonna give you a $0 bond. And I'll recall the warrants. What is your motion, sir?
I have a motion to strike and dismiss.
What are the bases?
Basis of federal rules of civil procedure. Number one, there's no claim. There's no ratification of the claim.
There is a claim. There is a. You want me to read out I waived the reading of the information. You want me to read the allegations that have been made into the record? Do you need me to do that?
No, I don't. No, I don't, Your Honor.
I deny your motion on that basis. What else?
Yeah, I was gonna stop here because Floor, your comment. Yeah, I appreciate that because on occasion I get people coming through here talking about, oh, well, you playing reruns, not knowing I'm doing a follow-up. But check this out. We all watch different platforms, right? You might have Netflix, Hulu, and there's some old shows out there that you will go back and watch. And the TV shows do it. Now, I'm not a TV show, but reruns are reruns. Some of these cases are good, and you want to go back and watch them again. There's nothing wrong with that. But yeah, I appreciate your comment.
What do you have to say?
You
What else?
You deny my motion because of what, Your Honor?
Yes.
There is no real.
I denied your motion because there is a and this is criminal procedure, not civil procedure. But I denied your motion because there is an allegation here.
You're saying, Your Honor, you're saying this is a criminal matter?
Yes.
Okay, well then we need the corpus delecti. And so that's what I'm asking for. If there was a criminal matter, basically what you're telling me is that something has happened, someone has either been damaged or someone has been or either someone has been damaged or someone has something has been come up missing. And if that's the case, then that means that there is a crime. And if there's a crime, then there is the what do you have that's saying that I did the crime? What you're saying that I created this crime that hurt this person. And if I hurt this person and I created the crime, then a third thing that you have to have is the identification of the person. You have the identification of the person, which is me, but you don't have a person saying that they were hurt or damaged, or the crime that's saying what I did to hurt or damage the person. So how do you have a crime?
Okay.
And when I put this up before, I was thinking that he's a nice sovereign citizen, trying to present it without really yelling. So it's still not going to go anywhere, but yeah, he's breaking that down. Let's see how it plays out for those of you who haven't seen it.
You went to law school?
No, Your Honor, I have not.
And where did you get that? Where did you get that from? Where did you learn all that?
I've been studying for quite some time, trying to understand what's going on. I have a different perspective as to what's being said that happened. I'm understanding more the procedure that is necessary for a crime to go for them to bring a crime forward. I'm understanding that a bit more.
And where did you get that understanding?
I've done some Cornell Law studies. I've also sat down with a couple of friends who have had some issues. I picked up wherever I could, just started to study the law. Just started to go back through Cornell Law, started to figure out what was going on, and to understand the nature of how what a crime is, and everything else.
Why don't you just say you were with your sovereign citizen friends who's already been to court, who tried to use that script and they pushed it to you and say, hey, oh, you're in a situation. Won't you try to use it and see how far it gets you? That's exactly what it is, because Cornell Law is not going to teach sovereign citizen language. No way.
Just a course of me searching it out.
And you're citing Cornell Law for all of that you just said to the court?
No, what I did, Your Honor, was I realized that one of the biggest portions that you have to have is you have to have the corpus delecti. And that is in when you're being charged criminally.
What is the corpus delecti?
What do you mean, what is the corpus delecti?
What is your understanding of what corpus delecti is?
That is the corpus delecti is the law that's saying that there is a crime that's being committed. So in order to do that, you have to show the corpus delecti, which is you saying this is what happened. This is how this person was damaged.
So
there is no
the
person.
Officer on these dates, because I got a lot of them, said that
I object. The officer works.
Don't interrupt me.
I apologize, Your Honor. I apologize, Your Honor. My apologies.
The officer says that you drove a vehicle that wasn't registered and wasn't titled, or titled and or untitled, that you drove without a valid driver's license, that you drove without valid insurance. Again, on a different occasion, they allege that you drove without a valid driver's license and no insurance. And then on a different occasion, they allege that you drove without unregistered or untitled, or both, and drove without a valid driver's license, repeat offender, that you failed to have a trailer plate, and that you failed to secure a load on your vehicle. And on another occasion, on the same occasion that you failed to secure, that they allege you failed to secure the load, failed to have a trailer plate on your vehicle, that you didn't provide a valid driver's license. So those are the crimes. And in state of Michigan, whether you agree or not, they are crimes. So based on your motion and all of that stuff you talk about, corpus delecti and things like that, the court denies the motion, okay? Based on those reasons I just said. Now, how do you want to move forward? Because wait a minute, I'm not finished.
My apologies, Your Honor.
How do you want to move forward? Because in my experience, someone that comes into court, as you do, you do not want to take an offer. You do not believe that you need to have plates or registration or insurance, and you just disregard all of that portion of the law. And either you are going to move forward by having a trial, or you're going to take a deal. What do you want to do, sir?
Your Honor, first I want to put my objection on the record. And at that point,
whatever your objection is noted. What do you want to do, sir? Do you want a trial? You have two options: trial, or you want to take a deal.
Your Honor, I request a jury trial.
A jury trial.
A jury trial, yes, Your Honor.
Very good. Ms. Mathis, I need a jury trial date, please.
You also notice, or if you have or haven't, what I've noticed is every time the sovereign citizens have to go to trial, they always pick the jury hoping they can get off because they're not going to go back in front of the judge. So that's one thing they do to avoid. They will not do a bench trial. Most of them will not.
And if I may, Your Honor, what time is Mr. Gray presently docketed?
I don't even think it matters, but I'll tell you. I don't think it matters. He's got the newer cases and the older cases are pre-trial at 8:35, Christopher Lamar Gray, and then he had some in warrant status. I counted 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 cases into the record. You know what I want to ask, Mr. Gray, and you can choose to answer it or not.
Yes, Your Honor.
But what I surmise and what I've heard, and I don't know if you're alleging the same thing, is that and you basically did allege the same thing, that no crime has been committed because no person has been, the people of the state of Michigan are in danger of you driving without the proper documentation or anything like that. But I don't, and I'm gonna surmise, and you can correct me if I'm wrong, that you're gonna say that there's no jurisdiction to be able to pull you over because no one has been injured. Is that correct?
I think that what I'm saying is that the city of Detroit had an officer pull me over to say that you're not following these rules. And my stance is, okay, well, then that's fine. If we're following rules, then therefore, let me make sure that you as well as are following the rules, because if I don't do that, then freedoms are lost. So that is that is the way that I proceed, to say, okay, well then if we're playing cards and we play and show me yours, if this is your hand, then this is mine, and let's proceed accordingly to the law. That's it. That's my only standing is, if someone doesn't stand up every once in a while and define the edges, then they all disintegrate and people lose rights.
No, the problem is that you're breaking the law when you're not up to standard, when you have a vehicle that you're driving or whatever the case is, and you get pulled over for that. That's his fault. But they want to twist it into something else and show me your hand and all of this. No, it doesn't work that way. And y'all already know this, but I'm just picking apart his little arguments because he's trying to make it sound good. He's really talking like he's talking like he's intelligent, but that stuff that he's learning in that sovereign citizen school, maybe he saw that commercial, it's not going to work.
And you know something? With that being said, I would agree with you 1,000%. That's why I pride myself, and I hope I'm doing a good job for the citizens that come in here and the police for that matter and the prosecution, that I am calling the balls and strikes right. And if something doesn't proceed as it should, then I will dismiss the case one way or the other. But in my short time on this bench and in my time at practicing law as a defense attorney, I get this, they can't pull me over. I've heard the corpus delecti, first time the civil procedure has been thrown at me. But from the way I see it, is that you just don't feel that the police have a jurisdiction to pull you over for these issues. Is that correct?
Do I have again, Your Honor, what I feel is that if we are following rules, that if I have to follow the rules, and every person out there, all of these officers, everybody else has to follow the rules. So if it comes down to it,
what I'm gonna hope that you do by the time you come back on the trial date, jury trial date is gonna be March the 18th, 2025.
Thank you, Your Honor.
You're probably gonna have an audience because everybody follows me on these cases all the time.
I understand.
All right, and I don't know if that's what you want, but we're gonna that
It's not
audience.
that.
March the 18th, 2025. We're gonna have a final pre-trial date. Final pre-trial, this is to you, Mr. Bowman, especially the day before on February 17th, 2025 at 8:30. So Mr. Gray and Mr. Bowman, Mr. Bowman, I need you to have all your officers appear on that date. Who's ever going to state these allegations, so that we know that we're not just summoning the people of the city of Detroit to a jury that's not actually going to go. So all parties must appear, and that can be via Zoom. And the trial is going to be in person. All right. All parties must appear on final pre-trial date and obviously on the trial date. And what I would implore you to do is you need to figure out the right game, because it doesn't sound like you're playing the right game.
I understand, Your Honor. I appreciate, first and foremost, let me say, I appreciate the dialogue. I appreciate you sitting here and engaging with me at this level. So I recognize what you're saying, and so I guess it's to the table we go. So
yeah, but get your game in order, because I'm just giving you a little heads up. If you come in with that game on the jury trial date, then more than likely you'll lose, unless you can find one of those jurors or a couple of those jurors, or even all of them, to have some sympathy for you, sir. I don't know.
I got a whole basis for understanding, and so yeah, if you know it.
Well,
it
that
is what it
basis
is.
that you outlined shortly today is not.
What was flawed in my what was flawed, Your Honor? What is
we
flawed
already
in
discussed it. We already discussed it. The federal rules of civil procedure that you brought up as a motion to dismiss, not the right basis. The corpus delecti, they do have a corpus delecti. They do have a crime that they say has been committed. And if you read the MCL, the Michigan court rules, and the Michigan statutes, then you'll see those crimes outlined there. They have them on the tickets. They got the statute numbers that are on the tickets. So that's not the right basis. So you're in a whole different ball game, and you need to come on to this ball game here.
Okay. All right. Okay. Well, I guess we will have that discussion again. I appreciate it. I also want to say I recognize and honor your compassion that you sit on the bench with. I see it as you go out here and you judge our people, and so for all of that, kudos, man. That's for where you sit. I appreciate that. Thank you, sir. Appreciate it.
I appreciate
Yes,
that.
sir.
Mr. Gray,
Yes, sir.
you have a
Yes,
safe
sir.
happy holiday season, sir. And
You as well.
best of luck to you. I'll see you back on March the 17th, 2025 at 8:30 for a final pretrial. And let me say this, let me add to the record.
Yes, Your Honor.
If there's any motions, those motions need to be in writing.
10 days, within 10 days.
Let's put that on the record to a motion. Those motions need to be in writing. Have those motions to the court by February 14th, 2025. And the response will be February 21st, 2025. And I'll rule on those motions on the final pretrial date of 3/17/2025. Again, all parties must appear, Mr. Bowman, all right?
Appreciate it. Happy holiday, Your Honor.
Okay. Now I'm going to go into a little of what's going on this case. And I see Jim of the North. I'm about to update what you just asked. So if you notice, and I know you heard, Judge Perkins asked the prosecuting attorney, Mr. Bowman, to make sure everybody's going to be there, right? Now, he didn't show up. So that means all the officers came and whoever was supposed to be there were there. Now he has another court date for a show cause coming up soon. And, you know, a lot of times we see, especially in this court where I've seen the officers don't show up, especially when they got something to do with these sovereign citizens. And I know they end up getting a lot of court dates because the motions, then they have the failure of peers in there. Like they stretch this out. And that's part of this script. Because one of the videos, I can't even remember now, that I talked about all of this stuff. So I'm not saying that their thing works, but whatever they do, it just pushes this court hearing over and over and over again and wastes time. So now he's going to have a show cause and they probably going to schedule it again. If he doesn't take a deal, he's coming back to court again. Is he going to show up or not? Because I've covered a lot of cases where the sovereign citizens have had something going on 2, 3, or 4 years back. And when I get a chance to look at it, when I have access to stuff, I see failure to appears like crazy or motions like crazy. Like when I did the last live stream with the other guy in the Texas court, what was it? Antoine Davis. He had so many motions going on. That case has been going on forever. Then he has a failure to appear. He's back. Now he has to go to court again. It just keeps it almost like it's starting the process over to a degree, but it's not. So this is what I see. So this case to me is a perfect example because he's so nice about it, right? Because we get caught up into the laughter and, you know, all of the drama that they do. And like, okay, yeah, they're being kind of, you know, like stupid or whatever you want to call them. But this one, because he was so calm, it gives you a chance to think like, okay, look at what he's doing. He was so nice, but didn't show up. So I just wanted to say that. I didn't want to go too long, but I was just trying to make this point about it because I have talked about this before. So we're going to roll to this one. This is one I put up recent. I said, okay, we're going to go out with a bang because this guy, he should get all the sovereign citizens. If you've seen it, you know what I'm talking about. If you haven't seen it, this is going to be a good one. All right. So let's check this one out. Let's go.
Court calls People versus Ryan John Hart, file 24-4935FH. Your Honor, Ryan Ziegler on behalf of the people.
Thomas Seeger appearing on behalf of Mr. Hart.
I have somebody in my hearing room listed as Ryan Hart. State your name for the record, please.
My name is Ryan John Family Hart.
I don't have anyone on my docket listed as Ryan John Family of Hart. I have an individual listed as Ryan John Hart. That's either you or it's not. You get to tell me whether or not that's your name. If it's not, then I need to call a different matter and bring somebody else into my hearing room.
Your Honor, I'm the representative of that entity, yes.
That's not an answer, sir. Your name is either Ryan John Hart, in which case you're invited to participate in the proceeding today as Ryan John Hart, or you're not Ryan John Hart, in which case I have no use for you to be in this hearing today. So tell me your name so that I can determine whether or not you're the proper person to be called in this case.
My name is Ryan John Hart. May I ask a question, Your Honor?
No, you may not. Mr. Hart, this is not a complicated process, and this process does not get less uncomplicated. When I call a case, I start by identifying the parties that are to the case. When I'm confident I have the correct parties to the case, I proceed then and decide how to go forward. In this case, your difficulty, and I think intentional difficulty, is affecting the ability of the court to be able to proceed and to conduct its business. That's relevant to a lot of points, but most importantly, it's relevant to a pending motion that your attorney filed, presumably on your behalf, but I sense that it's not only on your behalf, it's also on your attorney's behalf. And so we're going to take up that motion. But your difficulty in basic things like telling me whether or not you're the party to a case is thwarting the court's ability to timely get its business done. I'm turning to the motion now that's before the court today, which is the motion to have attorney withdraw and to have you represent yourself, Mr. Hart. The court does not find that motion to be well placed, and I'm not going to prevent it. And the reason is there are several steps that need to be taken in order for you to be able to assert your right to represent yourself. First and foremost, I must find that your assertion of that right is unequivocal. I don't have that. What I have is your attorney's motion, and I recall very clearly and plainly, the last couple of hearings that we've had. A couple of hearings ago, I had findings that I made based upon a competency and criminal responsibility examination. You were found both competent and criminally responsible by the court after assistance from the Center for Forensic Psychiatry and after an in-depth intervention and interview by them. I made the findings, your attorney agreed with them, and the prosecutor agreed. I have not once heard you make any type of unequivocal request at all. What I instead heard when I consider whether or not there's an unequivocal request for you to represent yourself is your attorney explained to me, I think this was 2 or 3 hearings ago now, that he was somewhat conflicted. And these are not his exact words, but this is what I recall from it. He was somewhat conflicted. You had wanted him to file various different motions, which the attorney did not find were supported by law. And the communication that I had in response to Mr. Seeger, again, was some version of this. I told Mr. Seeger that as the attorney, he and he alone chooses which motions are to be filed and which are supportable by fact or by existing case law or by the extension of existing case law. If he can't make those arguments that are good faith supported by law or an extension for the law, then he's not permitted to file the motions. It was at that point that Mr. Seeger then suggested that another solve for him could be that you could represent yourself. In other words, the implication that what Mr. Seeger was making is that if you were representing yourself, you would not be constrained in the way that he is. It would allow you to file whatever frivolous motions, I'm using that word, Mr. Seeger didn't, whatever frivolous motions you wanted to. And so the request to have you represent yourself as made through your attorney is not found, number one, by the court to be unequivocal in any way. Number two, I would have to go through with you and be confident that you understood the maximum penalties associated with the crimes. I have every reason to believe that you understand the maximum penalties, but I have every reason to believe that if you and I had a discussion about what those maximum penalties were, you would express confusion and you would not express a knowing, confident, and voluntary understanding of those things. And so I'm not yet even going to get to that second step. I also, of course, would have to, under People versus Anderson, the binding Michigan Supreme Court case regarding waiver of constitutional right to represent yourself, I would have to make specific other findings. And those findings specifically are that I would have to determine after a conversation with you that you acting as your own attorney would not disrupt or unduly convenience or burden the court in the administration of the court's business. What is plain, obvious, and unarguable in over the last 2 or 3 hearings is that if you were permitted to represent yourself, you would make the court's administration of justice difficult, you would delay matters, you would be disruptive, and your representation, therefore, of yourself would be unduly inconvenient to the court and the court's operation of its business. For that reason, even if I found that you otherwise made an unequivocal request, which you haven't, even if I found that you clearly understood and you expressed your waiver knowingly, intelligently, and voluntarily, the court would still not grant your request through your attorney to represent yourself under specific circumstances here.
This judge doesn't play. And he's going through all of this case law so fast, he doesn't have room to talk. Now, if you put sovereign citizens up in front of this guy, this judge, they don't stand a chance. And I'm sure if they talk all of that mess and try to overtalk him, he'll put him in jail. I can see that because he's very strict and it seemed to be by the book, the way he's kicking all of this information out. So I really like this judge.
It's my firm finding based upon the background that I'm aware of that to allow you to do so would only encourage you to file what are very spurious and frivolous motions. It would waste the court's time. It would waste the prosecutor's time. And although it would waste Mr. Seeger's time to have him remain on, the court also notes that even if there is good cause for Mr. Seeger to withdraw, the Michigan rules of professional conduct allow the court to continue an attorney's appearance and order that an attorney continue on a case even when there's good cause to withdraw. And so I choose to exercise the discretion provided to me under those Michigan rules of professional conduct and the Michigan court rules and Michigan case law in denying any request to have you represent yourself. You are and will remain represented by Mr. Seeger until further order of the court. Mr. Seeger, did you need then some time to discuss the effect of that ruling with Mr. Hart before I decide how this case needs to resolve?
I do, Your Honor. Additionally, Your Honor,
Your Honor, I have something to say. May I speak?
Mr. Hart, You don't get to decide when things are set. That's again part of the issue.
The judge has not let me speak
Presenting
at
yourself.
all in more than three.
Mr. Hart, this will not be an argument. This case will not proceed by me talking over you or you talking over me. Court proceedings by law and by procedure, Mr. Hart, are to be ordered. And they're to be in a specific order, and that order is dictated by the trial court judge. That's me. It's not dictated by an individual who's charged with criminal offenses, you. And so I'm going to exercise my discretion to control those proceedings. You right now, Mr. Hart, are free on bond. I don't particularly have any care as to whether or not you're free on bond or whether or not you sit next door, except to this point. For today, I'm going to expect that you disagree with my decision on your motion to have you represent yourself. I'm going to therefore excuse any further appearance of you for purposes of today's hearing and today's hearing only. I'm going to set this matter for a new hearing after I hear from your attorney and from the prosecutor. That new hearing is going to be set in person. The reason I choose in my discretion to set it in person is because if you're disruptive or unduly burdensome to the court at the next hearing in person, I'm going to view it as a violation of your bond conditions. And if I view it as a violation of your bond conditions, you're going to be subject to the contempt powers of the court, which includes me revoking your bond and you sitting next door. Because if I have your bond revoked and you're sitting next door, I'll know that Mr. Seeger can locate you and communicate with you. And if you have your bond revoked, I'll know that I'll be able to better control the situation than I can over an electronic communication like we're doing now. Because as you've demonstrated, the only way I can control the proceedings right now is to mute you so that you can't speak over me.
This is beautiful. It seemed like he has a script sitting back there. He needs to pass that on to the other jurisdictions. I mean, he's going through everything step by step as to what they do. And he's like counteracting everything before they can even get to it. And now he's muted anyway, so he can't say anything. But the part that I really like, he said, yeah, I'm going to bring you in here. That way I can control the situation. You're not on Zoom. That is golden right there. And so I'm going to let it finish, but this is good stuff.
That's not an effective way of running a courtroom, but it's the only way that I'm given your attitude, experiences, and your frustration. Mr. Seeger, did you wish to make a responsive record?
No, Your Honor, I do understand the court's ruling and I clearly will abide by it. Be that as it may, Your Honor, and I will discuss this with Mr. Hart. There was an amended offer that was extended.
Can you please speak up so that Mr. Hart can clearly?
Sure, Your Honor. There was an amended offer that was extended, which is much more favorable than the previous offer. I will discuss it with him. He can determine how he wishes to proceed.
All right. Did you want to, for purpose of the record, state that offer on the record?
Your Honor, my understanding is that he could plead to one count of attempted resisting and obstructing, which would be a misdemeanor in lieu of dismissal of the attendant charge together with the habitual offender.
What was the habitual offender notice that was charged?
It was I don't have it in front of me, Your Honor, because I just had the motion.
Your Honor, he's subject to a habitual 4. I believe it's on the information.
And I just didn't have the file in front of me, but do you disagree with that, Mr. Seeger?
No, Your Honor.
All right. So, Mr. Hart, it's very important that you not only hear the offer that's been made as an offer to an attempted resist and obstruct charge for dismissal of the existing charge as well as a habitual 4th, but it's fundamentally even more important that you talk to Mr. Seeger about that. He can give you advice. You ultimately get to decide how to proceed, and it does not matter to me how you proceed, so long as you proceed with the understanding that court procedures require structure, and that structure will be followed by you and by anyone else that's in this courtroom, or there will be alternative options considered by the court. Mr. Ziegler, anything further on any of that the people would like to offer?
No, Your Honor.
No, sir.
All right. The court will set this matter for a status conference next month. I will require that everyone in this matter be in person for the reasons I've already explained. Mr. Hart, you're free to sign off now. I expect you'll talk with your attorney and be here in person next month. You'll get a notice in the mail.
He looked so sad at the end and frustrated at the same time, but that's what he get. The judge muted him, so he had to deal with it. But unfortunately, when he came into court, they are not aired, so I can't get it. I don't know what happened with him, but I could probably just do some research if you want to know what the end result was. But yeah, when when they're in the off camera like that, we don't get none of that stuff. And I hate that I miss it because I like to follow it to the end. Even for me, like I want to know what happened. So I hope y'all enjoyed everything tonight. Cause yeah, I had the one new one, and then everything else is just follow-ups and funny stuff. Just was to hang out on a Sunday night because I like hanging out with y'all. So I did 2 lives this weekend, which is unusual, but I had a good time when I wanted to just bring this to you. You got a new commercial out of it. So anybody that came late, you go back, you'll find a new commercial. I'll throw it up as a short. Oh, thank you. Thank you. I appreciate the comments that's coming in. Yeah, appreciate that, Aqua Queen. Oh, okay. We got Rob here, the lawyer. Oh, it was bound over to district court. Okay. Yeah, I just didn't get a chance to look everything up like I wanted to. Yeah, I appreciate that, Bertha, Karen. I appreciate your comment too. Just as you see at the bottom, anybody want text notifications only for lives and only for premieres. I will not be sending out messages when I put out new videos. I just want to make sure you can be on with me when I start them up, since I hear so many complaints about YouTube notifications not working and people getting here late. Okay, good night, Juanita. Appreciate you coming through. Oh yeah, could y'all hit the like button either on your way out if you haven't done so, just to support the video. I'm just going through comments. Y'all don't mind. Okay, appreciate that. Love y'all too, because y'all always here hanging out with me. Oh, you got to start over. Oh, you came late. It's all good. It's all good. So, yeah, wherever you are, have a good day, evening, or night. And I'll have some more stuff coming this week. And I'll see if I'll be able to go live again over the weekend. Okay. For those of you who have been getting the text alerts, great. Thank you for all the members. Thank you for all the subscribers. I'll see you next time.